Okay, this is CRPD course, and I am very happy to present a guest lecture by Alberto Vásquez. He is someone who was very actively involved in the Peruvian legal capacity reform, and he's going to talk to us about that today. So over to you, Alberto.
Thank you, Tina, and thanks everybody for joining. So let me do a brief overview of what I was expecting to share with you today. I think I was thinking to do a very brief intro about what has been achieved with the legal capacity law reform in Peru. Also, what are some of the limitations or things that need to be worked better. A substantive focus on the process itself, the key success factors according of my evaluation, and finally the remaining challenges of this reform. So as many of you may know, in September this year, Peru passed a major reform on legal capacity. And to understand the context of this reform, Peru is a civil law country. This is a country in South America, 30 million people, and it's a country that has a civil law tradition. What does it mean? Like opposite to common law countries or Islamic-based countries, in civil law countries, codification is key, and this codification of the law is key, and the civil code is the main piece of legislation, really, after the Constitution. So changing legal capacity, it means changing the main piece of legislation, and capacity itself, it's at the center of the civil code because it regulates and touches upon all the different areas of law that are regulated in the civil code. So that's why many countries that are actually trying to do law reform in civil law countries are trying to do it outside the civil code. For example, Colombia is doing a proposal, very ambitious too, but is trying to pass a legislation on support. Costa Rica did the same. They passed a legislation on autonomy and support. In this particular case, let's say we dealt with the most hardest process, which is actually changing the civil code. And as you may know, it has been this reform has been recognized by the CRPD committee. The chair of the CRPD committee has publicly recognized the importance of this law reform. Also, the Office of the High Commissioner of Human Rights issued a statement. The Inter-American Commission of Human Rights, which was a nice surprise, also took notice of this reform. And finally, well, the office I work with, the Office of the Special Rapporteur on the Rights of Persons with Disabilities, also highlights some of these issues. So what has been achieved? And if you have checked the law reform that we translated into English, you will see that actually we changed 3 pieces of legislation: the Civil Code, the Civil Procedural Code, and the Notary Act. Because again, you have to keep in mind that in civil law countries, notaries play an important role in assessing capacity and ensuring legal capacity related to contracts, related to patrimony, related to administration of assets. So that was key as part of the reform. But there are, I think, 4 main achievements of this reform. First, the recognition of the full legal capacity of all persons with disabilities. And for doing this, we needed actually to clarify first that we are also talking about capacity to act. And you may be familiar with this discussion, but during the negotiation of the CRPD, some countries were trying to force the interpretation that the capacity to enjoy rights was universal, but not the capacity to act. And so for us, it was important that the law reform could clarify this, that capacity to act, that legal capacity includes capacity to act, and the capacity to act should be enjoyed on equal basis with others for people with disabilities. So that was one of the key achievements of this law. A second one is the abolishment of guardianship based on impairment or disability. And that means taking down a long-standing system of guardianship in Peru, and guardianship that has been inherited through Spanish legislation during the colony, and that goes back, as you may know, to very old forms of representation from Middle Age. So this is a very key success factor. I will discuss a little bit what does it mean guardianship based on impairment later, because we may have still other restrictions on legal capacity for other groups of people, and we can discuss that. But let me keep that statement: abolishment of guardianship based on impairment. A third key success, I think, is elimination of restrictions to legal capacity, because when we think about very formal ways of restricting legal capacity, it's not only about guardianship, but also the right to marry. We needed to modify legislation to that because it was restricted the right to make a will, access to justice in the Civil Procedural Code, it was denied to, and also the fact of the Civil Code permitted placement into an institution for the purpose of care or protection by a judge or third persons, including, of course, the guardian, and that was abolished too. So that was also a key aspect of this elimination of all the restrictions to legal capacity. And then we have the part on more linked to support. First, the law, I think very importantly, because I didn't see much of this in other pieces of legislation, makes a difference between the obligation to provide reasonable accommodation for the exercise of legal capacity and the obligation to provide access to support or recognize support decision-making regimes. So that difference, I think, is key, because it will help to understand better that one thing is you don't need a formalized form of support because there is an obligation to provide reasonable accommodation in the exercises of legal capacity. And that may imply accessibility measures, as the general comment number 1 on legal capacity of the committee puts forward, but also means that informal support could be provided, and that's part of the reasonable accommodation. So I think we will need to explore that during the implementation. But for me, what's important to have this difference, and for me, something very particular of this piece of legislation. The second thing is supporting decision-making regimes, and the law goes towards the idea of advanced planning and the possibility to appoint supporters in case in the future you may need support to exercise your legal capacity, but at the same time, the possibility that you control when this process starts, how this support measure is triggered, and it doesn't imply declaration of incapacity. That was also the direct implementation of the general comment number 1 on this. The second thing is support agreements that are basically private contracts. Of course, today you may say, why don't you do that? Because your legal capacity actually is restricted, so you needed to recognize that. But this support agreement could or not include representation. Actually, the law establishes that it doesn't include if not expressed. And this is a very flexible measure that could include one or many supporters, institutional support, individual support. So it's a very flexible measure. And finally, and you can do it directly with the notary, or you can register directly with the notary, you can do it directly with the courts. But finally, we have in cases, and the wording is very particular if you have seen it, when after significant efforts to determine the will and preference of the individual, and there is a need to protect the rights, a process exceptionally could be started, to determine the will and preference of the person, to explore a support measure. It doesn't mean that that support measure will be forced into individual, but the process is actually to explore what the individual wants, including the existence itself of support. And as I said, this is a very residual measure. It should be placed, and I think that's one of the key challenges of the text. It's not completely clear, but I think as a systemic interpretation will be helpful when it needs to be used best interpretation of the will and preference of the individual, but that's implied in that particular measure that we will try to do, if not express, because this is a very exceptional case, we will this process will be based on the best interpretation of the will and preference. And in general, that's a key aspect, that support must be based on the will and preference on the person concerned. And I think that's a cross-cutting measure across a cross-cutting safeguard that is across all the texts of the reform. As I said, this is a very long reform. Some wording won't be the best. So I'm trying to give you here actually what is my interpretation of the text. But I think is fairly representative of the text. So what are the limitations? Or what are some of the limitations? So I think one of the key limitations is, and that was a setback for civil society, is that the initial proposal was to eliminate completely guardianship for all people, not only for people with disabilities, because we have guardianship for many groups. Drug users could be placed into guardianship. It's actually a specific type of curatorship for administration of assets, but it exists. We have this notion of prodigals and bad administrators, which are very old provisions. In the particular case of Peru, because this you may find this in other contexts. In the particular case of Peru, this is an objective evaluation. Who is a prodigal? It must be somebody that expends more than 50% of the whole patrimony, affecting people that will benefit from the heritage. So it's a very objective standard. It's not linked to mental capacity. It's more about affecting the future heirs. We have a guardianship system for prisoners. So all of them will remain. And that was a setback. And in addition, because we couldn't get into agreement with the government about, okay, but what happened with people in coma, which honestly we thought this is a very stupid question from the government. So also they created a new category called restricted capacity, where all of this group will be now. And for people in coma, in situation of coma, there will be a restricted capacity, but if the person has already established advanced will, or has another form of support, I mean, those will be respected. But even as a less option, support measure will be applied in this particular case of people into coma. So even for people into coma, the idea will be to explore through this exceptional proceeding what's the will and preference on the individual. So that didn't end that bad. But that's one of the challenges, because if you keep curatorship, it's not gonna be guardianship anymore, but curatorship is gonna be basically, and the reform is clear, it's gonna be basically about administration of assets. So if we keep that for other groups, the risk, of course, is some people with disability may be affected, especially when you think about the profile of some of the people that are put into these measures. Like in the case of prodigals, the risk most likely is that people with dementia may end there. In the case of drug users, it will depend, but so this is a continuing conversation. I will explain later why the government was so reluctant to change this particular issue, and this is about the process itself. The second challenge, I would say, is the issue of that while Peru doesn't have a standing alone mental health law, it has some provisions regarding mental health in its General Health Act. And civil society and people with psychosocial disabilities has been working on this for a while. So in 2010, if I remember well, a new piece of legislation changed one article of this General Health Act and actually introduced it for the first time the concept of involuntary hospitalization and treatment in the Health Act. However, the reaction of civil society, including key institutions like the Ombudsman Office, helped to abolish that reform, take down this involuntary hospitalization and treatment, but the General Health Act states that treatment can be provided without informed consent of the person in case of emergencies. And though this is repeated in the article on mental health, it's actually all around the law. You have it in Article 4, you have it in the part of rights of individuals. So in general, Peru has an exception for informed consent in case of emergencies. And of course, the interpretation is that that includes what they call mental health emergencies. And namely, this is being applied in the cases of risk to self or to others. So we can come back that in the discussion, but of course, that's a big challenge. And I'm afraid that that won't be changed through a legal reform unless the legal reform takes away expressly the notion of mental health emergencies, because as I said, this is a general provision. And of course, the interpretation is discriminatory applied to people with psychosocial disabilities in crisis. But as I said, the law doesn't talk about directly about involuntary hospitalization and treatment in the particular specific part of mental health. So I think it's a very complex situation. We need to work with it. And we have an issue of data also, that we really don't have a clear picture of what is happening, especially in the context that the government is selling this notion of community mental health. And in the last 4 years, because of this law reform passed in 2012, so the discussions around hospitals have been dropped for new discussions about how to implement mental health services in the community, though, of course, with very few involvement of users and survivors and people with psychosocial disabilities. So those are the two main limitations, I would say. One related with other groups that could be applied in a way that could target people with disabilities. That's a risk. And the second one is how we deal with this issue of exception of informed consent in case of emergencies and how this applies to people with psychosocial disabilities in relation with mental health services. So let's go back to the reform. So the process leading to the reform has been a very long one. And I'm really telling you, this was a long-term strategy. I remember having conversations in the beginning with the key leaders of the initial reform, which was a reform of the passing a new general law on persons with disabilities for implementing the convention. And at the beginning was, can we include the reform on legal capacity in this omnibus law that we did? Because we passed a new disability legislation that made reforms in many pieces of legislation. So the question was, at that moment, when we were drafting this is 2009. So at that moment, the question was, are we ready to do this reform? And the honest answer was from everybody, no. So what was was foreseen was a cumulative process. So in the first step, the idea was to recognize generally the need, the general recognitions of legal capacity of all persons with disabilities in the disability new legislation, the new disability legislation, but at the same time, in this piece of legislation, acknowledging expressly the need to reform the civil code to end the contradiction between the civil code and the disability law and the Convention on the Rights of Persons with Disability. So that was the first step. And just to this initial piece of legislation, we got a lot of resistance, particularly on the issue of, but you are creating a contradiction with the civil code. Even for that, we had to advocate. But then when this was passed, that was a really good strategy decision, because what we achieved is that the law created immediately a new commission, a multi-stakeholder committee at the Congress with participation of civil society. And because the initial disability framework that was adopted was drafted by civil society, and indeed civil society campaigned for 2 years or 3 years to pass this piece of legislation, we foresaw the composition of the committee. So we had people with disabilities sitting there and key allies that we were already addressing sitting in this commission just to reform the civil code. So we worked 1 year on this commission. I was one of the members of the committee, so I really participated in the discussions in the committee, and I can say it was a hard process. First meetings were terrible. People, as you may expect, will say, honestly, we don't need to change everything. We don't see the contradiction within the civil code and the convention. Article 12 based on a general comment that helped significantly in the discussions and helped to change the minds of many of the members. But what changed more, it was really being exposed to each other to discuss, to work, to chair readings. And one by one, they were changing their positions. At the end of this multi-stakeholder committee, everybody agreed on the need to end guardianship. And it was amazing. This is 2014. From 2014 to 2015, 3 congresspersons, the representative of the judicial system, the ombudsman office, everybody was in favor of ending guardianship already. And then we work on the proposal on designing a system that will be useful for everybody. And in this designing, civil society again took the lead. And I remember having meetings in cafeterias at night, sitting with the representative of different organizations, people with psychosocial disabilities, and working on the text. And that text was presented at the committee, and basically the committee supported it. Which was interesting is that helped us also to control the narrative in terms of how much involvement we wanted of the judicial system in defining, for example, the support regimes, how much involvement we wanted really from families in being the providers of support. So that helped to shape the way we wanted this reform. But at that moment, to be honest, we were very few. And I will explain this a little bit. After we had disability laws, work is done. This is your problem. This is a problem of people with intellectual and psychosocial disabilities. You do it. So we were at that moment those remaining working on this. That changed after, but at that moment, the drafting process was that. And then with that final bill that came from that committee, we started to work again to try to gain back support from different DPOs. The problem is we didn't have enough time to advocate government change, and we needed to present a new we needed to present a new bill for the new Congress. And that was actually the final process. New drafting, an improved version of the bill of the committee, we ensured support from multi-parties, for different political parties. And finally, because the process was taking too long, the executive decided that we were already also in contact with them, decided to say, okay, why don't you give me to the Congress? Why the Congress don't give me the legislative power and I can pass this? So that was the final position. And because of the delegation of legislative powers only included disability, that's why they couldn't take down also other forms of guardianship, because the legislative delegation was very precise on disability. That was one of the limitations. But the process was not only about law reform. In the last 5-6 years, different organizations, we were doing different things. So for example, an organization I ran in Peru, we were doing training to the judiciary. We will put in diplomas on disability and human rights, and later legal capacity to judges. And that helped it, because then you will have some judges that believe on this and can speak up. So we needed to diversify the voices. So that really helped it very well. And some judges were key because they were challenging guardianship already through law case law, and pushing pressure of the reform. But also we were working with academia, particularly with one university, the Pontifical University of Peru, and also working with notaries. So we didn't have much people, but we could go to a meeting and bring one civil law expert, one notary that will support the reform. And that was key too, in terms of diversifying the voices. But as I said, at some point we were alone, those with intellectual and psychosocial disabilities. We needed to get back DPOs. So we started working on it, and there is a platform of DPOs and NGOs working together. So we put again the law reform on legal capacity on that space. And we work for many months with raising awareness. We did some training to them. And also so people can understand that this is not only about people with intellectual and psychosocial disabilities, that in practice, blind people were also having restrictions on legal capacity. For example, when going to the bank, they were not allowed to do some proceedings without a third person. So we were looking for these entry points to make it a case not of one group, but all the disability community. We didn't achieve that with other groups, and that's a pity, like older people or drug users. And I think it's not only that the disability community didn't look for it, but also we couldn't find good organized partners to work on it. But this multi-level strategy also included working with media. We had a lot of publications in journals, newspapers. We were looking the right angle. Somebody from Alamo, which is an organization, people with psychosocial disabilities, came with this great idea that we needed to have different angles to this campaign, not only talking about human rights, and nobody will necessarily pay attention in the media, but we needed to talk about a story. We needed to talk about stories. We needed to tell stories of people efforts being hindered by guardianship. So we created this narrative where guardianship was this monster that was actually preventing people to come out from different difficult situations, including the hardships of actually getting the pension, the hardships of getting a contract, an employment contract. So instead of focusing in the more traditional narrative that we used to do before, in terms of involuntary treatment, institutionalization, we actually started to put also on the table stories that people will relate more, that people will feel, okay, I feel related, because this is a more universal topic. It's a double-edged thing. but it helped. I think it helped a lot, that at least with media. And finally, we felt at the end of the process that when everybody was ready to actually adopt this legislation, some people were saying, yeah, but how would this look in practice? So we jumped on trying also to do some demonstration projects in terms of peer support and support decision making, just for the sake of having the argument that we could present something that is actually working. So that was kind of the strategy we did. Was, as I said, this looks very systematized, but in reality, it was a mix of strategic planning, but also a lot of improvisation. And we will add new layers in the strategy all the time and rethink of the strategy. So let me go to some key success factors that I feel were key in this process. And I think one key factor is having an organized and diverse civil society. I cannot imagine this reform being adopted without having organizations, people organized. Because I don't think that this could have been done just by individuals. And I think the organizational context help it and support, because you need to canalize funding, you need to have many people in many places at the same time, you need people with different skills. So having the umbrella organization at the beginning was key, because that was key for passing the first part of the reform. But then having a coalition of DPOs where DPOs of people with intellectual and psychosocial disability could be part of it was key. But because let's face it, this is basically something that affects mostly people with psychosocial intellectual disabilities. So we ensure it all the time that those voices were there, but also that new voices emerged from those collectives. And we had new advocates coming and getting interested and joining. I mean, at the beginning, I remember the work with Alamo, but then we had Asumen, we have other organizations. Even within those organizations, new voices emerged. That was an important process. I think the second factor was having a shared agenda, that everybody will align around the CRPD. That also was key. I think we didn't have that before. And since 2008, we had this agenda, the CRPD agenda. It helped too that for some DPOs, funding was on the basis of working on a CRPD framework. So those voices that were not necessarily in line with the CRPD were those that actually won't get funding, which was a good thing. So that was key in terms of the role of international cooperation on this. And I think I was reflecting for a while on this when we had so many things reforming at the same time. It was in Peru, at least, it was in the 80s during the International Year of the Disabled, that also opening a door of aligning all the voices, and people got together and did some reform. And I feel like reforms in 2012 and 2018, we had many. All of them are linked to the CRPD and the opportunities that open it. But just having an organization, a civil society, and having an agenda, I think was not enough. I think the fact that many leaders emerge in the process, many people, but at the same time, some key people remained the same during the whole process, and some of them providing strategic thinking not only in terms of content, but also who we needed to address, how we needed to address it, and splitting the roles was useful. As I said, leadership with systemic vision, the possibility of having a small group of people beyond the civil society itself, a small group of people that will be constantly thinking in terms of we're playing this chess game. What's the next move? Where we go? who we need to convince. Is this an opportunity? Who wants to take the lead? Having all the time people doing this strategic thinking, it was key for us. And we have been doing this for a while. And sometimes this strategic thinking will open new opportunities. And you may take advantage or not of them. A fourth thing is strategic alliances. And this was between and beyond the disability community. Early, we realized it. We needed human rights organizations at universities, but also media. So we were looking for key partnerships. And at some point we said, okay, let's face it, we need to work with all the political parties. And it was a hard decision for many of us. I used to work with the left in Peru, and my former mentor was the leader of the left party. But we needed to work with the right-wing party too, and we needed to work with the Fujimori party, which is a terrible thing to do in Peru. But we needed all the parties to support this reform. So we did it, and we split roles. We have different approaches with all of them, and without having this multi-party bill, it would have not passed. We could have just been comfortable and presenting something only with the left. It was easier, but we could not have achieved what we have achieved, and we did it without compromising. And I think that's an important lesson too, that you can actually approach something you don't necessarily support, a group you don't necessarily support, but you put your conditions, and it doesn't mean that you have to give up your own principles. So we did it, and I think it worked. But then we used also some windows of opportunities. When we thought, okay, this is over, the Congress closes and we didn't pass the legislation at time, we will have to start again. We thought, okay, this is an opportunity maybe. Maybe we can approach the new candidates, the new parties, we can approach the candidates for president and convince them to put this as part of their platforms for campaigning. So we did that again, and actually the president, the government of the current president included in his platform reform the civil code on legal capacity for persons with disabilities. And of course, people promise whatever in campaigns, but the key is you achieve that and then you try to hold it accountable to their own proposals. So everything is a little bit of a leverage. And then revolving door opportunity sometimes, and this is particularly my case, at some point there was an opening in the Congress. They needed an expert on this to deal with this legislation. So I volunteered and I went there. I worked with the Congress and I helped all I could to pass this from inside too. It was not enough, but it helped. So we were really working as, I would say, most pressure groups do, trying to make of the best of opportunities. And finally, I would say having funding. I mean, we can try to do grassroots work, but to sit the judiciary and do some diplomas, to work with media, we needed funding. And we got some funding from DRF and OSF. And DRF left at some point, and anyway, the funding was very small from DRF. And then we worked with OSF, and that was key. So I have been talking for almost 30 minutes. Let me finish with this, and then maybe we can back to questions. So what are the remaining challenges? First, there was no, what we call in the civil law context, vacatio legis. There is no period between the formal enactment of the law and when it comes into force, which means that when we adopted the legislation in September, the next day that was published, all the authorities should have been implementing it, including judges. Of course, they were not prepared. In fact, civil society recommended to put a 3 months period or 4 month period for preparing the implementation, but the government said, no, let's implement it now. So systems are not prepared. Not only judges, which are improvising basically. Notaries, they don't know how to recognize systems of support. Civil servants, they are between resistance but also inertia, so they keep doing what they have been doing forever. So we need more awareness on this and to work on the implementation. We need a systemic cultural shift from civil servants, service providers, and there has been awareness, but there is a difference between raising awareness and actually telling people how the implementation should like, and that's a big thing. And the second big problem is the structural aspects. So people with disabilities in general live in a context of very strong poverty in Peru. Very few go to education. There is something that I probably exists the term, but rights illiteracy. People don't know about the rights at all. So they don't know that they have the right to refuse treatment, or they have the right to challenge their family if they want to impose their will. There is no much support scheme in place. So everything is more about natural supports, and even peer support is just starting in Peru in the case of people with psychosocial disabilities. So we're really starting from scratch. But also I see a lot of opportunities. Since the legislation has been adopted, there is a huge demand for training from the judiciary that is asking, okay, who can provide this training that we need? And this is a key opportunity for civil society to jump and say, look, we can do this, we can put something in place. There is a demand for new services. There is this context of the mental health reform that is not clear where it's going. But most of us think it could be a good opportunity to change the narrative for more involvement of peer support, peer-run services. And finally, I think I keep thinking on this, and I think the disability movement itself, and for me, and social movement in general, I think success helps in building and strengthening movements, because it creates this, I wouldn't say legacy, but it creates this new narrative as of success, where people get the hope they need in terms of, we can do something, we did it, so what's next? And I felt that this is the moment we're living in Peru, from the general disability community, but also people with psychosocial disabilities. We have never been so full of hope in terms of, maybe we can change this. Maybe this is the moment we change how it works, mental health, for the system in general, for example. No, so I think it has been a good push of enthusiasm for us in terms of doing new things, and we're just starting to do new things. So I think that was key for us too. So that's it for me for now. So maybe we can pass some to some questions or comments.
Okay, thank you so much, Alberto. That was really great. I learned a few more things from listening to you than what I had already known from hearing about it and from reading the materials. So I'd like to open it up for questions. Sometimes people prefer to write in the chat and I can read it out, or you can take the microphone. Okay, Tasman has written a question in the chat. I'll read it out. Under the CRPD, does the government have an obligation to provide adequate training to the judiciary and others in disability and on how to interpret the law? So does the government have that obligation to provide training under the CRPD?
Well, Yeah, I mean, the Convention on the Rights of Persons with Disability and Article 13 already states that the importance of training the judiciary. In the case of Peru, the law itself establishes the need of the judicial system, because it's independent of the government, to ensure the right implementation of the law. And what we have seen is there is a new program called Access to Justice for Persons with Disabilities that is very keen to move forward with the implementation, which is positive. But something for me in terms of strategic thinking is I'm very glad that at some point we decided that we needed the less involvement of the judiciary in implementing this law. Because if you read the law, it's actually a very residual role in terms of the hardest cases that is hard to understand what's the will and preference. So I think a legal design can help also to foresee these problems of implementation. If so, so what I'm trying to say is, if we think ahead and you reduce the role of the judges, I think that will be an easiest response to this question: how we ensure that the judiciary actually implements the law. But because this is a systemic issue that goes beyond the judiciary, of course, the question is who will train the notaries and who will train the civil servants. And that's for me, that's a harder question than who will train the judiciary. Because at least with the judiciary, you have a clear target. They have a judicial academy, they have a program of continuous training with the program of access to justice. But notaries are individuals that are hardly organized. So, for example, just to put an example, what we're trying to do now is how we ensure that we can have some training to the notaries towards their own networks and organizations. But that means convincing them that this is a good reform. We had some allies that helped in the process, but now we have to expand that. And that will be a challenge again, because they may end being the new gatekeepers of the implementation of the law.
Yeah, that's really interesting about the notaries. And I think it's interesting to hear from you how in the strategic thinking the different focus needs to move all the time, and working with the needs and the possibilities as they come up. That I think is really fascinating, as as a lesson that in some other countries there may be a different process, a different trajectory that you have to move through, but that way of thinking, I think, is really valuable to take as an inspiration. Um, I think in terms of the CRPD obligations that Tasman was asking about, there's also Article 4 to cover anything that's not necessarily part of the court. So um, I don't know if that's. I think in Peru it was clear from what you said that there is this obligation, and Tasman may also be thinking about how it could work in other countries. Is there any other questions for Alberto? You can take the microphone or write in the chat. Well, I can ask a question in the meantime, because I would like to give the possibility to others. Um, okay. Emmy's asking, do we want to switch on our webcams? We can do that. I can switch on mine. But I'm not going to keep mine on if nobody else wants to. So we'll just see what anybody's doing. Hi, Emmy. Did you have a question? Do you have a question, Emmy? Do you want to take the mic?
I'm just wondering, how do you educate people on the difference between legal capacity and mental capacity? Like, I don't know. Like, I find that people have a difficult time understanding that.
Yeah, I think people got confused all the time. Even now, after the reform, people keep confusing it. I was not particularly afraid of people. As somebody that has been working with politicians, because at the end, politicians are the ones making the decisions. So I have the impression that sometimes it's easier to avoid some discussions and to give people directly the answer. So what we did in this particular case, we have this discussion in the committee, a long discussion about the difference between mental and legal capacity. And I think some of them got it. But I think the bottom line for us was every time we came to the discussion, for us it was okay, but there is an obligation that everybody has legal capacity. I don't care about the mental health, the mental capacity. Let's put that aside. Let's put that aside for a moment. Then they will say yes, but what we will do when we don't understand what the person wants to say? But then we'll say, but that's a different question. You see, and then we will go to the re-answers. So from the beginning, we had the answer for the difficult case, and we said, okay, in this very exceptional case, and we may rephrase it and keep improving the wording. We said from the beginning, let's put this on the table. The hardest case, we will try to do a best interpretation of will and preference. So let's put that on the table from the beginning, so we don't come back to the questions about the comma. We don't come back to the questions about people who cannot communicate. But let's think about other ways how we deal with the middle part in terms of, okay, accessibility, reasonable accommodation, a third person supporting, if we really need to put that on the text. But we really close the discussion with the best interpretation of the will and preference. That really put them off, because they felt, okay, then you have an answer for the hard question, for the hard cases. And we said, yes, we have an answer. We need to deal with this seriously. We need to put a specific process. The process will be different, though, because it will be about bringing out the will and preference on the individual, not replacing it. But having an answer helped it. And I felt that changed the way we used to do, because we used to say, we don't have an answer for that. That's a difficult case. I think nobody will have an answer. And they will say, you see, we cannot do anything. Nobody have an answer. We did it differently this time, because this has been a trial and error. I said, we have an answer. With that cases, the CRPD committee already said this is best interpretation, though has to be exceptional, has to be in these particular cases. So they felt that the place where they always come back for guardianship, because they always come back to this particular case, we need substitute decision making, we had it covered. What I must say is also that people never understood well the relationship between the mental health legislation and the civil code. They never got well. Why? Because we don't have a very sophisticated system of mental health. So we don't have a lot of safeguard, we don't have a lot of those discussions. That also helped it, because we may squeeze things and nobody came with that was not a question, for example, or not a very common question in terms of, so what happened if somebody doesn't want to consent treatment? That was not really part of the discussion. We had responses prepared. We will have always response prepared. We will never have no response prepared. But it didn't come out very often. Why? I think it's just because for most people in the civil law system, especially, guardianship is a thing, mental health legislation is something else, and in many civil law countries that are not following a common law, because mental health legislation actually is not very intrinsic of the civil law system. It's something that we started to create later, and we keep adapting and adapting and adapting. We never did it in Peru, so it's not something that we really have that so much in mind. And because of that, I think the question of mental capacity didn't came very much, because we don't have a test to evaluate if somebody can consent or not, in which cases. That's not something that we do. And probably because of that also didn't came up so much. But so just improvising, two learnings there, I think, is we really had questions already preparing most of the meetings. We had what we will say, and we were anticipating questions, and we were meeting. And as I said, that was a small group. At some point, we were like 5, 6 people sitting, representing different groups. But then that kept expanding and expanding. But always we kept this small leadership group, let's say, that will consult and come back to their own organizations. But we never work in a very big platform with 200 people trying to discuss something. That was not the case. We were more like, okay, you go back to Alamo, you discuss that. You go back to Down Syndrome Society, discuss that. I will go back to people working at academia, discuss that, and we will do that instead of doing very expanded discussions.
Thank you.
I have a question about still trying to understand some of the things about the mental health aspect and the health aspect generally. So, and also some of what you were just saying about no process to evaluate whether someone can consent. So when a notary is deciding if someone has the legal capacity to consent to enter into a contract or to execute some particular document. So this is just one first question. Are they making that? Are they not making that kind of assessment of mental capacity as part of it, or are they just doing a formal, check, say, okay, this person is not under guardianship? So that's a question. And then does that, if that exists, does that not come in relation to health decisions? So that's one question first. And then you can answer, and then I'll ask the second part.
I think we really need to pay more attention of the role of the notaries. We have been overlooking it, and I think that also shows how the discussion has been dominated by common law experts in the issue, because the role of the notaries in civil law contexts is about mental capacity assessment. It's not just that certifies a document. The notary is the one that guarantees that both parties wanted to do a contract. So to do that, they do a capacity assessment. I was surprised learning to this process that the legislation in Peru didn't regulate how they do it. Basically, it says that the notary have to confirm the will of the parties in agreement, but then their own work, they do they work on different tests of capacity. I would say the Peruvian was very rudimentary. They will ask the person, what's your name? Which day is today? Very basic, what they call very medical oriented questions in terms of, are you located in time and space? You know where you are, you know which day is it. and you know who you are, basically. So some of them have very basic questions. They don't deal with mental health legislation, or they don't deal with consent to treatment. That's not part of the role. The role is about transactions, legal transactions, contracts, wills, legal procedures. So they don't really, and they keep asking, they keep telling you that at the end, look, if this person have a diagnosis, but today in my office, know who she is, what the person wants to do, that's it. I grant the document, because they grant the formal document. So it's a very interesting role that they play, potentially harming, especially, I would say, potentially harming to people that don't look or don't behave as what people will deem normal, because then they will be scared and they will say, no, I need a medical examination or something. Bring me something that says that you don't have any potential problem, and somebody will question your will. So that targets a lot of people with dementia, and targets a lot people with intellectual disabilities. Most likely won't be able to do any transaction in a notary, most likely in most civil law countries, especially people with Down syndrome. Even if they can respond all the questions, they will be afraid that there will be liability against them. And with people with psychosocial disability, it was strange, because at the end is, if I don't see the problem, I don't care about. So it's a very ambiguous way. I think we need to deal with them in terms of, because we cannot eradicate them. This is part of the system. But now we have actually the challenge in terms of, so we're working with them. What's a non-discriminatory certification of the will of the individual? Because it's true, they are the ones that have to grant that both parties want to do the contract. So they see themselves now as a safeguard that the will be respected. Whatever the person wants should be there. But then I see the risk of being those preventing people to do legal contracts if they feel that will damage them. So, because that's already inherited in the role. They do also the role of advising. So if you're going to do selling your house for a very small price, they will tell you, sorry, you shouldn't do this, because this is not the price of the market. So they have this very paternalist, it's a very paternalist system, the notaries. And I think people don't realize how big is it, and how that's why they feel so important, because at the end they regulate all these qualified legal transactions.
Yeah, I think I come from a common law country, but I remember at different points in conversations I've been part of, we did talk about notaries and started to think a little bit about what that should be like, and the whole notion of reasonable accommodations and systemic accessibility in relation to legal capacity was partly in response to thinking about people dealing with notaries, but some of us thinking about that being from common law countries wasn't necessarily, coming from really good understanding of what the notaries were going to be doing. But it sounds like you have, I don't remember what the law actually provided or changed about notaries, but it sounds like you have in place the basis to work with the notaries to make sure that they can do a non-discriminatory certification of the will. So, I mean, that sounds like that, that is fixed in principle. I mean, that exists in principle. Okay. So in a healthcare situation, let's say let's say a person is in a hospital, and take an example of a friend of mine. A person has end-stage kidney disease, and she wasn't in the hospital at that point. A person has end-stage kidney disease, and she does not want to be hooked up to a dialysis machine however many hours a day. She would prefer to stop the treatment, and even though it means it's going to hasten her death. Do you have something where somebody in the health system, whether her doctors or her family members, might say, might challenge her so-called mental capacity to make that decision? I mean, it could be via a threat of guardianship, which now you don't have, but is there any other kind of avenue by which in the health system generally somebody's, I mean, it sounds like a notary wouldn't be involved in that, but yeah, and I forget how the health law is written in this regard, but is there anything like that exists in the health system? And then there's going to be another part of the question about the mental health pieces.
Yeah, so yeah, it's true. The notaries won't be able to deal with it. That's the good thing, and I keep insisting on this in these discussions. I mean, I think we need to get rid of this exception for emergencies, but there is a thing having an emergency exception than having an involuntary treatment rule, because then in this particular case, there is no way to force a person to get the treatment. There is no way. You will have to force that's an emergency treatment in case to try to do it, because there is no measure that will forcing somebody to have an operation. That's beyond the law in Peru, because now there is no guardianship, there is no way to do it anymore. So you will have to pull out too much in the case of emergency. So I think that case, there is no solution in the Peruvian legislation, and the person has the right to refuse treatment.
Okay, so the person has a right to refuse treatment. Okay, I mean, I'm just thinking of the way that's actually a very common kind of thing. We have all these bioethics boards and in hospitals and things like that, and I suppose people with dementia, as well as people with intellectual disabilities and psychosocial disabilities, are facing that kind of thing. So, and I guess your system has really done it pretty much through guardianship at this point. So or maybe just hasn't done that very much at all. So in relation to emergencies, is that something it seems very broadly framed to say that in emergencies there's no need for consent. Because, for instance, let's say you get injured in an accident, and from an objective point of view, somebody would say, you clearly need treatment, but you're conscious, and, there's an objective injury that if you don't treatment, you might bleed to death. But you do not want to deal with doctors, or you have a religious objection, and you just want to walk away. So can you walk away? Or is it that because it's an emergency, they can and will just treat you? Is it that kind of paternalism? And then if it is that you can walk away, then it sounds like implicitly there is a mental capacity thing going on. And can you bring in the right, because that's in the general comment also, that you have legal capacity at all times, including crisis situations, which should include medical emergencies. And then you have the best interpretation as a last resort. Can that work? Sorry, I'm not. Turn on your mic.
Sorry. I think that's what we should do. And that's what we need to go. We need to go to show that this is being applied in a discriminatory way. Because the person that can walk away of the accident because it's communicative have the right to say no, but then the person that is communicative in a so-called emergency situation has no right to say no. So that's discriminatory. So because then if we apply that, when we talk about emergency, it's actually that we don't know the will of the individual, then the interpretation could be something that we can figure out. So I think we should go where you're saying, that rather than saying we need to eliminate the emergency clause in the law, that is not going to happen. I think it will be, okay, let's make it non-discriminatory. Let's say if somebody doesn't want medical attention, that's it, for everybody on equal basis. And that will, I don't know how it's going to work, but I think we should go there. We should explore that avenue. I think that will be the better way to get out of it. Because as I told you, I think before, I find very difficult to rechange the whole system of the health legislation, not because they don't want to change it, but because it will have to be that we will have an exception actually on mental health positive, you know? So that will be strange to regulate.
Okay, I guess one other question then. Why is there, I mean, two things, like why is there a specific section on mental health? Why is the need for that? And then, I mean, I hear you about being hard to regulate, and maybe in the context of Peru, it's not even, maybe in your context, it's not even being used in the intense ways that we see it in some other countries. But okay, I mean, maybe what you can do is to end up really developing a strong interpretation of what it means to do this best interpretation of will and preferences. And I think you have the basis for that in the civil code reform. I think you do have the basis for a strong interpretation. So, for instance, to get rid of, to close out any way of thinking that some German lawyers are promoting, this idea that there's a difference between the natural will and the free will, and also the related idea that they have that someone else has to be in the position of deciding if the person expresses ambivalence or has an internal conflict. So I think if the best interpretation of will and preferences really is a process of figuring out what the person's will, it's a process of inquiry. It's not a kind of fiat decision. Then you have the basis for that way of thinking about it also. And I guess, but then the question that I still have is, why do they have a separate provision on mental health? And then it may be still a bigger issue, but why is mental health seen as health? Oh, and then how is this danger to self or others thing coming in? Where does that actually exist in the law, or just in the law's application? Because that you have to get rid of. If that exists in the way that the idea of emergency is being applied in mental health, that may not be something that the best interpretation can deal with. So thanks for this discussion.
Why we have a provision on mental health, I mean, it has been always there. Actually, surprisingly, it's quite small. I mean, when you think in terms of most countries moving towards standing alone legislation on mental health, and the whole discussion that mental health has been underdeveloped and there is no investment, that's what you get as a policymaker. And I'm telling you, as somebody that worked for many years at the Congress, that will receive all the time information from the World Health Organization, from all the stakeholders, put more attention on mental health. So we had already in the legislation something on mental health. What happened in 2010 was that we got a very strong non-rights-based provision on mental health. And what we did is reframe again the text that was already on mental health in this, let's try to push for a different narrative. To some extent good, to some extent not so good. And it's a mix of really in part of we failed to totally change the narrative in that particular article. Though we get rid of some things, we couldn't get rid of everything. There was a pressure to having something on mental health. So the way out was to push as a final provision of that reform to a mental health reform. And that was agreed by all the different stakeholders. I must confess, I feel very disappointed of the process. I felt that will be a game changer at that moment. This has been 2011, 2010, when we started that, and we thought, okay, maybe this is the right thing. And I remember really all the stakeholders were happy with that. Let's push it towards transforming mental health systems. So towards community-based, forget about psychiatric hospitals, similar to the experience of Argentina and Chile, but in a way that was more even radical. It didn't change what we thought. It has created some opportunities, but at the same time, as we have seen everywhere, the system is just repeating themselves in the community. So that's the explanation, actually, to have a provision. It has been always there, and there is a lot of pressure to have something on mental health. And mental health for most people in Peru is nobody think about people with psychosis or people with different. No. The mental health in Peru is drugs abuse. That's the main driver of mental health policy. Is consumption of alcohol, consumption of drugs. That's what Thinkon is thinking. And most of the new services that are being provided in the community are basically counseling for drug consumption. Domestic violence is also part of the equation of mental health. So they're doing a lot of counseling to end domestic violence. So it's a different discussion. I realized that we were pushing too much on, and they said, no, this is not about disability, because they don't really care about putting people into beds, because the pressure of the society is not this person is violent. The pressure of the society is different. So at the end, each community has the different triggers. And that has been really hindering the work, because as nobody cares really about, even in the community, I mean, beyond talking with Alamo and Asumen and a new organization that is being created, the first top in the agenda won't be involuntary treatment. Because we don't have so many beds in the country anyway. This is not as coercive as other countries. People is more concerned about, and I think this is the big global South discussion, and the North, the discussions is more about, look, I cannot get a job, we don't have income security, we don't have. So this frames again some of the entry points for people and I feel that's why the disability community, like people with psychosocial disabilities in Peru, feel more close to the disability community rather than a separate group working as users or survivors, because many of them are not even users because there are no services. So I think that defines also your identity, and it really explains a lot in terms of why in the global South many people is more identified or embracing faster this notion of people with psychosocial disabilities, because there were no other identities before necessarily. You have a small group of survivors, particularly in countries that have long traditions of institutions, Chile, Argentina, Brazil, but Peru is was a poor country until very recently, and probably it's very similar in Brazil. Sorry, in Bolivia, or in some part of Colombia, or in Ecuador. You don't have service. You have complete regions without a single psychiatrist. Complete regions. So the other day, somebody was coming to do some training from Spain. That is a very active activist, and she was asking me, "So we're doing training, but they want me to talk directly with nurses, not with doctors." And I said, "It's probably because there is no doctors there. What they're doing is training nurses to do counseling for different things, because they don't know that there doesn't exist a system, but it's strong. So that's why the less part of this it's a very sophisticated discussion to have these questions with the system when they say, look, you want to talk me about coercion? We don't have a single doctor in that region. So what I'm trying to explain is why some issues have more impact than others in the discussions. Still, I think in some regions it's a problem, and as the system will grow, that will be a problem. So that's the moment to address it. In terms of self to others and that's not in the law, but the regulations of the Ministry of Health have it, and it's there, and we have been challenged it with Elaine and other people, and we're now have to discuss what's the next step in terms of reframing the whole thing. What we have in mind is that we need to collect some data, some evidence of how this is working. We don't want to stay in the discussions about the law or the regulations and the principle, but we really want to understand what is happening, because that has been our strategy always, to show the difference between what says the law or the regulation and what is actually happening, how many people is being deprived, because that could help to put some pressure. But we really don't know. We really don't know. I mean, you can do an estimate for the number of beds in the hospitals, but in Lima, you only have, you have 80% of the beds, I think, of the country, or something like that, or 70%. It's a poor country, really. A different situation. We need to deal with in terms of data, collecting the data.
Yeah, I mean, I see that makes sense, because if it then turns out that there's actually that's just that standard or that idea of danger to self or others is just something that is there because somebody from WHO told them to, but it's not actually even being the way that people think about mental health hospital admissions, then that could be easy to get rid of, or then otherwise you figure out how to deal with it. You mentioned that that drug and alcohol consumption is one of the biggest pieces in how in what mental health services are. And then I think we really, if that is, then I think we really do have to even more look at that provision in the civil code on drug users, and also the fact that in the mental health law itself, it does still have involuntary treatment for drug users. So, I mean, that's something that was raised to me, this issue, when I was in Brazil earlier this year. Does the CRPD cover people who are drug users as a disability, people who are addicted, who have a problem with the consumption of drugs? And I thought that actually in the CRPD committee's concluding observations on Peru, that they mentioned the both aspects, the both parts, the involuntary treatment of people with mental health conditions and drug problems. And so that seemed to me like, okay, so the CRPD committee at least recognized that. And, I think the question, should it be considered a disability? Do we want to promote for it to be considered a disability? I think if it's being addressed, I have a little bit of a blockage on this because in the U.S., in our Americans with Disabilities Act, I think there's a mixed point of view on it, that people with active drug and alcohol issues may not be considered people with disabilities. But that seems to me like an important thing to address, because when in the Brazil seminar, there was a person who is a public prosecutor, which I understand as an institution in Latin American countries is a kind of public defender. It's not just a prosecutor who prosecutes criminal cases. And she was saying that she had been using the CRPD to argue for greater rights for people with drug problems or problems related to drug use. So I just wanted to ask about that. How do you see that as something that should be within the disability community, or is more something that's that's an alliance to be made with a different community?
I used to work at the Ombudsman office at some point also. Like I work with like many, in Peru, this is the National Human Rights Institution. And we work on the issue of drug users. And we have been evolving also in the concept from drug addicts to drug users. Because and at the beginning we were talking about about addiction, and we were facing the issue that for many drug users, addiction doesn't exist. That it's a label from the psychiatric community. So, but then at the same time, from the medical community, they will say, addiction is a mental health condition. They are part of people with disability, and they were open to expand the notion of disabilities to include them. When we had the discussions about the mental health legislation, I personally tried to contact groups to work with it, and it was not easy because this was not necessarily part of the agenda of the groups I got into contact. Many of them were more working on the issue of decriminalization of drug consumption, and also in legalization of softer drugs. So the issue of people involuntarily treated, which is a big problem in Peru, because we have a lot of small so-called communities where they are sent, community for treatment, and the conditions are terrible. But what I felt is that from the disability community, we were maybe missing the angle, and I like it that when the review of Peru was in place, and that's why the disability community put it there, in terms of the idea of perceived disability, you as having a mental health condition, but not necessarily I felt that the groups will identify as people with disabilities, because they felt there was no actual impairment in general. So not so far from some discussions in the community of people with psychosocial disabilities, indeed. But my impression is, as somebody that is not part of that community, I cannot drag them to the discussion. The disability community tried, but it's true also, but because we don't know them, easily we drop them when we needed to negotiate, okay, what's the no-go? Drug users were not on that was not something that the disability community said, no, we cannot go without them, because we really didn't have anybody on board. And that's an issue, and I think it's an issue of we need to build a strategic alliance with them, And that's my impression. I went once to a meeting in London. Was in London? I think it was in Ireland, with organizations, global organizations, drug users, and they had this in the agenda, and they were using the CRPD as a way to defend themselves, but at the same time, not necessarily feeling that they were part of the movement. They felt they were not part of the movement, that they were drug users. There was no need to have a new label, but using the CRPD as a good entry point to avoid forced treatment and deprivation of liberty and access to justice and other things. We need to basically to engage more with them, because I think it's true also that many people overlap in those groups, and that's a reality that we need to explore. I cannot hear you, Tina.
Sorry. I was saying that in the community of users and survivors of psychiatry and people with psychosocial disabilities, to give all the different identities, more or less, we either need to take all of us out of a medical framework, or else we need to somehow allow for many different constituencies within those of us who are now lumped in people with psychosocial disabilities or users and survivors of psychiatry. Oh, can you still not hear me? Or is it just Emmy? Can you hear me now?
Yes, I can hear you.
Okay. All right. So that, either we have to take the whole thing out of a medical framework, or else we have to somehow, and we have to allow for this notion of perceived disability to include many things. And I think for many of us, the notion of psychiatric diagnosis really is nothing more than a label that's put on you to shame you at a point in your life when you are really struggling just as a human being, like any human being can struggle in your life. And if you get this label put on you, and what I call the ceremonial degradation of being locked up and being put under forced drugging and other forced interventions, then it's hard to simply get rid of that label. You can call yourself a survivor and you can say, well, no, I don't believe in the concept of mental illness. If you say, well, there's nothing wrong with me and there never was, you put yourself in a situation where people might start to debate you about whether there's something wrong with you. And then, who wants that? So from my perspective, and the parts of the movement I've been involved with in the US, and to the extent I've been involved globally, we've tried to put the identities together in a way that we're talking about everybody's rights at the same time. But I feel like if the focus is going to be mental health advocacy, I'm not part of mental health advocacy if it's dealing with the notion that there's an actual impairment, or that there's some kind of that there's something that's wrong with you that doctors can identify and put any kind of a label to. If that's what mental health advocacy is going to be, that's not me, and I want out of it also. The same way as I hear many autistic people saying, take us out of the mental health basket, the same way people with dementia are saying, take us out of the mental health basket. So I think that this may be an issue for the movement to be discussing and thinking about, because I think to some degree, some of these differences are global South and global North issues, but to some degree, we have the same kind of organizations in the global North that are not prioritizing an end to forced treatment. Of course, we have those organizations, but we also have the ones that are, maybe because some of our countries are just, I don't know. I mean, I don't know, but the development of the whole sector um, of advocacy in this area may be bigger. I know in the United States it's huge, and you can't even keep track of it. But we have organizations that don't prioritize coercion. Most of them don't, and yet the CRPD, I think, does and needs to prioritize. I mean, doesn't prioritize one over another, but it does guarantee that not one person should be locked up against their will in psychiatry. Not one person, because it is arbitrary detention. So that's just, I mean, I don't know. That's more of a reaction than a question, I guess. But I'm just, I don't know.
Maybe
Yeah.
I can add something very practical, actually. What I have been seeing in at least in Peru is, I mean, if you sit most of the, and you know many of them, actually. I don't know if you know Julio or Elena or other Daniel, other people from the movement. Everybody will go on board with the whole package of the CRPD, including absolute prohibition on the privation of liberty. It's just, I think, more about what are the priorities may be different. It's not that people don't see it as something important. It's just it's not part of the priorities of the day-to-day experience. But that's something that for me that has been growing and growing in terms of an issue is when you don't self-identify as a person with disability, in many of our countries, you won't get access to services, including disability benefits. And that's a risk that people is facing. Of course, that's your decision. If you don't want to self-identify, you don't get access to services, and probably that will be also based on access to your own income if you have. But as you can imagine, in most low and middle income countries, that's a key discussion. Disability benefits, social protection schemes. And if you talk about perceived impairment or perceived mental illness or whatever we want to frame it, you're out. And if you're out, you don't get those. So I think that's something just to put on the table in terms of when people self-identify, that factor is always there too. And I feel that's driven the agenda. And now, as you know, we're working on building a new Latin American network of users, survivors, people with psychosocial disability, mad people, and it's amazing the number of identities we have, all of us. Some of them don't believe in the disability names and don't believe in the survivor because it says why we're just working on that angle when we have to look at all of our human rights. So there are many things on the table. And I feel we won't get into agreement. So, and we have this meeting in December, and the meeting one morning is just to discuss our identity. And I think it's gonna be an open one that could help to everybody use. But my challenge will be, I think personally, is that some people may don't want to even be close to the CRPD because that means that we're aligning with this identity of people with disabilities. So and that's not because they don't agree on it, but because should that be the agenda of the group? And I think those are the questions that will arise, and those are defining your identity, define your agenda. And it's easy when it's your own personal agenda. Everybody can do whatever they want. When you have a collective space, how you ensure that the agenda of everybody is on board? And we have been discussing this, and I see some people that is more interested in fighting psychiatry. We see some people that are most interested in CRPD, and there is other people that is more into embracing diversity, let's say, or art, math studies. So it's interesting that I think that's a challenge as a collective, how we build a shared agenda, but keeping in mind that having different identities will push us to different goals.
Right, and could even end up splitting the movement or making there be outgrowth. So I feel like my core fight is as a survivor of psychiatry, and the notion, the framework of torture and reparations and legal capacity from a point of view of preventing, of essentially articulating a right to personal and bodily autonomy. That's not the same as the privacy right that would allow people to abuse and exploit others. That's more a right of the person and their bodily existence. And I know that's not everybody's priority. And what I'm hoping is that we can all that we can all end up appreciating the different identities and different points of view, and figuring out how they relate to each other. So I think in terms of the CRPD, we do have perceived disability, and the reason for Peruvian civil society to have pushed that might have been in relation to the drug users, but we were pushing it from WNUSP in relation to this whole question of, that most of us, that all of us who have, I guess, in the community of users and survivors and people with psychosocial disabilities, there's people who would identify as having an actual disability but might not have been perceived as such. And there's those who would identify as having a perceived disability, but we don't claim any, actual disability. And then there's the thing of sometimes you want to reject the diagnosis, but you want reasonable accommodation and support to exist without having to claim a disability. You want the reasonable accommodation to support just because you have a need. And so similarly, the way that in your civil code reform, a person doesn't have to be a person with a disability in order to request support in relation to legal capacity. So I think similarly, we would want, myself and I think for some other people, we would want support in the area, support for what's sometimes considered mental health needs and reasonable accommodation to be available without having to say, I am a person with a disability, or having some kind of diagnosis. I wanted to read out Tasman's point that he says, I sometimes think of myself as being disabled for administrative purposes. So I don't, if you have anything further response, I want to give you the opportunity, but also want to just invite more people to jump into the discussion. So I'm seeing the chat. So Alberto, if you have a further response, and then I'll read out Jenny's question.
And I see your point, Tasman, and I think that's the challenge for many people that needed to self-identify as people with disabilities or disabled for administrative purposes. And I think the example of the disability pension is one of them. And one of the main challenges is the difference between this group and other groups is that the gatekeeper is the psychiatrist. And that's hard to challenge. Because at the end, the one that will say, yeah, you have a psychosocial disability is basically the psychiatrist that also have the capacity to enforce coercion. So that makes a big difference with other groups. And what I see as somebody that, I mean, I do follow the discussions on social protection. We're pushing towards more inclusive social protection, and that includes how we rethink the notion of disability benefits in a way that they don't have to be attached or to a assessment. But I don't see the countries buying it because of the cost. It's not the same to offer access to support in general that could be mainstream than actually paying a disability pension. And that's a big challenge. And I know from people even from TCA Asia and other parts of the world that that's one of the big challenges. More than this, I mean, discrimination, of course, you shouldn't be needed to prove that you're a person with disabilities to access reasonable accommodation. And I think more countries are buying it. But I don't think many countries will buy to actually take out money from the pocket to give it to you if you don't prove that you have a disability. That's a big challenge. Should we join other efforts in terms of universal social protection and minimum income? I mean, there are other ways to do it, of course, but for many countries, that's not going to be realistic. So, and we have seen it in South Africa. People do a lot to get a certificate because that's the only way actually you get funding from the government. The only pension pension mechanism that exists in South Africa is the disability pension. Zambia, the only cash transfer disability pension. So that pushed people also towards this particular identity, I think.
I mean, we even see that in the United States. We see people very cynically, I mean, cynically is not the right word, but by necessity, just claiming mental health conditions because they can get a disability benefit from it, and even many people going into psychiatric institutions and the mental health housing situations because of poverty, and because the poverty is so bad that it is, you know, that this is a better alternative for them, which itself is a really terrible thing. So I want to read out Jenny's question. She says, I would like to see financial benefits offered to people on the basis that they are stressed instead of them being viewed as quote unquote disabled, though I'm not sure practically how you would draw the boundaries to define what stress includes or how to achieve that, since the idea of disability is so entrenched. And then Emmy has questions after that, so go ahead. Yeah, okay, go ahead.
From the comment of Tasman, from Jenny, sorry, I think something that comes to my mind also is, I think this is a longer discussion with the community also, because I don't feel that this discussion is part of other members of the disability community. And that could be for many reasons, the notion of impairment itself, and I think the deaf people move from this rejection of the identity of disability towards more and embracing the notion, despite claiming that being deaf, it doesn't mean to have an impairment. But I think it's less resistant now. I think it will come also to, I think we need to keep in mind that rejecting some identities could be part of what we are also learning in terms of we don't want to self-identify of this community. I think it's tensions are always there, and that's part of what we do.
Emmy, go ahead, please.
I have a few questions. Oh, okay. Actually, I have some comments about the definition of disability, but I will not discuss them here. I think I will write some. I was Jomo was saying that, and Shushta was saying I could write something for Matt in Asia, so I will post in that Absolute Focusation group when I write it. And then I have a question about the strength of the disability movement in Peru and how well accepted the disability frame is. Also, and how did Peruvian civil society engage with people with intellectual disabilities? And then actually also a question about how the global North can be in solidarity with the global South and appreciating our different priorities. Oh, and also I wanted to make a comment about like how in Singapore we also have this difficulty of people not wanting to challenge coercive psychiatry. Although in our case it's more of people not wanting to challenge authority and just wanting to take the less controversial issues. But we also don't have any disability pension, and like I'm just kind of screwed once I graduate and don't have any money and I don't know how I'm gonna live. So it's quite bad. Like blind people and people in shelter workshops are expected to live on less than $1 per day. So I have no idea how that works. But yeah, it's pretty depressing.
Thank you, Emmy. I feel that the disability community in Peru is strong, but not the community of people with psychosocial disabilities. So we may need to do a difference. Indeed, the umbrella organization doesn't have members with psychosocial disabilities. And the umbrella organization in the last 5 years has been very reluctant anyway to work with anybody. They were a key ally working in the first part of the process, getting the new disability legislation, and for them, that was it. But then other people that wasn't part of that created a new platform. This platform is called the Committee on Disability and Rights. And there you have different groups that were like the ones that were in the outskirts of the initial discussions. And people with psychosocial disabilities, though they are not formally part of it, they were, particularly Alamo, they were involved in the whole strategy about this legal capacity reform. And I would say that some organizations, as the one I run in Peru, which is more like a nonprofit, were keen in terms of helping those groups to get on the table and get in the discussion and trying to ensure that nobody are left behind. So since the outset, since 2013, when the committee started, we supported Alamo and Down Syndrome Society, who were kind of the key representatives of the different groups, to have an agreement. Let's work together from here and keep expanding, but let's work together. Let's not leave the ones that are more. So another group of people with psychosocial disability joined, and other groups. But it was a key understanding that we were not the most representative one of the movement. And from there was, okay, how we convince the platform to work with us, and we kept moving. But you can count with your hands the very active people with psychosocial disabilities involved in the negotiations. There were not so many, but they were strong in the way that, okay, let's go back to our organizations, even if organizations are not particularly strong, to discuss this. And we had some workshops, and we sit with the people. And I felt that the organization of people with intellectual disabilities were also responsible. So we had a lot of self-advocates discussing this, and we had workshops, we discussed things. They were always the ones talking in the meetings. So we didn't want just people repeating things. We really want people understanding, and you can feel it. Even if you see a couple of videos, people with intellectual disabilities really got what this was what this was about. And that was good. And for me, that was a learning process in terms of, okay, maybe different people have different times, so let's work all together. But we didn't have a strong. I think thinking in terms of when we think about the distinctions, it was particularly in the drafting. In the drafting process, the families of people with intellectual disabilities were more keen towards involving more the family in the solutions of the legal design. But because of the involvement of people like Julio or Daniel or Elena or myself, the drafting went in a different direction, and we found the balance between the different aims of different groups. That most of us saying, look, most people that we know don't want the family involved in making decisions, so we cannot repeat the mistake of the guardianship system that relies on families. So let's think outside this, and of course, if you want your family member, you can appoint it. Let's put that, but it's a different thing. So I think having different voices help it. And I have seen many processes in other countries that, because it's dominated by people with intellectual disabilities, or not people, even families, it's going in a different direction, the reform. And it's all about, even in Spain, you see the law proposal for Spain for legal capacity reform. First, the wife of the husband. Second, the sibling. Third, the grandfather. So that's not a form of support. That's really repeating the system of guardianship. So I think my impression was that you don't need so many people, but you need people involved, engaged, and sometimes people don't have time, and time sometimes has to be buy. In terms of, okay, we can get some grants so people can work full time on this. Yes, maybe that will help. So that was something that we to be professional lobbyists, let's say it, although lobbyist is a terrible word, but in practice, that's what you do. You go to the Congress, you sit, you wait sometimes an hour to get a meeting, you get a meeting with the congressperson, you try to connect, you go to the next one, you have somebody at the Congress helping you to get the meetings, because otherwise you won't get the meetings. So you work in a very professional ways at some point that really, for a period, we hire somebody from my organization to just be in the Congress, getting meetings with people with disabilities, and helping us to get the pass, because even just getting into the building was difficult. So this person will say, don't worry, we will help you to get the pass. And then, anyway, that's the procedural aspect. The meetings was the meeting of the people of the movement doing their work, but we needed somebody opening the doors, helping to get the meeting, making the contacts, and you realize that's why we get so bad regulations in legislation in general, because that's how most people were doing lobby. It's a very professionalized system, and you have people. What I'm trying to say is, I don't want to tell you a very idealized process in terms of like everybody got on board because they believe on this. It's just because we work in a way other groups work, putting pressure, talking with the right people, building alliances, promises. The Congress people will do a press conference, you will be there, you will support this proposal. So they get up, because a politician wants recognition. That's why they will support you. So we're trying to do things in terms of getting recognition. Of course, always in the framework of, this is our principle, we won't change, we won't support publicly the Fujimori party or something on those lines. but we will do whatever is needed in terms of, sure, somebody of your party should be in the press conference, and that will be great. And we did many things like press conference because they needed some public recognition to support this. And at the end, for us, it was even better because they will commit publicly to do something, they will have to vote for it. So it's a lot of getting into the system and how it works. And as I said, many of us have been working on this for a while. So we kind of anticipate the reaction of the people. So we will say, okay, this person is more conservative. Be careful what your angle with them. These people is more progressive. You can be more open about what do you think in terms of what they're doing, how this connect with other issues that are broader. So we will frame the discourse all the time with different people, for notaries, for judges, for politicians. And so I don't know, that's what we do. That's what we do, at least in my organization, that we help people. We do some briefing, policy briefing. We do even media briefing with people that of the movement that will go to talk with media. We will do some media briefing in terms of how do you deliver 3 messages. Don't tell more, just focus. So that's kind of the work we do, and I think that has been useful because it's very practical tools to people in terms of how to do advocacy.
I really admire how people with intellectual disabilities themselves were able to advocate, because I really don't know how to get past the gatekeepers in Singapore, but yeah, I guess that's kind of not the main point, right, in this discussion. So I was wondering, because I asked this question also in the previous discussion with Janice, and I was wondering how the global north can be in solidarity with the global south, appreciating our different priorities.
Sorry, I didn't get how the global north could be
in solidarity with the global south while appreciating our different priorities.
I think you don't know sometimes, but you're doing it. You're paying your taxes. That is coming as a form of international cooperation to us. That's not so obvious. I think for us, and this is unfair, we learn from what is happening in the global north because everything comes later to us. So, for instance, we know that we need to oppose community treatment order. That is not a good step towards reducing coercion. That's not going to happen. So, but that's because we didn't have it, and probably very few countries in the global south we have this. So, because of the lesson come later here, we already know what we should face or we should challenge, and like mental health legislation. I know people in Latin America advocating against mental health legislation because they know what it comes with. So I think it's not so far. It's not so different. I think the bigger difference is that societies are more conservative in the north in terms of dealing with different individuals. That individuals are labeled as different, not only people with psychosocial disabilities, but actually every type of difference. The global south is more used to this in terms of, and because of that, the agendas are different. So they will be more, liability is not a big issue. The issue of if I tell people that somebody will get sued because didn't provide treatment at the right moment to somebody that killed themselves, that's not a case for a doctor in Peru. There is no case there. That will be a case in New York. So those things are main drivers of agendas. So I think what we need is more understanding only of why the agendas are so different for different groups, and respect that and work together what is common. And I think one thing is common, of course, is legal capacity, deprivation of liberty. Those are common agendas. But but we need to fine tune in the other agendas of social protection, housing. Do I believe it's the same at the end? It's just not necessarily maybe what the people is coming from now. But it will emerge. What we're doing in Latin America now, for example, is at this moment we're individuals, as many of people, as many of you in TCA Asia Pacific. But we have this idea of how we build local movements, local organizations, and I think that's going to be part of the discussion. A group of individuals to organizations, because then it's too much pressure on people to do all the work in terms of policy change and policy advocacy. So we're trying to go back to organizations. We will have to discuss that in the meeting, and if it's a possibility that from the regional hub we can fund organizations, as TCAH is trying to do, or TCA Asia Pacific now. But I don't feel I don't feel why this should be so different in Europe or in other parts. I feel like what it may be different is where we're coming from. Trying to go, I think, is very similar. And because of where we're coming from, we may act differently. But it will keep evolving, and it doesn't matter so much. But even if we take the lesson of the process in Peru, having a shared agenda, that's what's the key. Let's find what we can work together and what we all agree, and then everybody else can do their own agendas. But let's find what we can work together. And I think that was helpful, because otherwise people feel this is making compromises, and I think that didn't work very well in Peru. It was better to leave everybody do whatever. Everybody was doing different things, but let's focus on legal capacity reform. We all are together on this. And a new team to work together in Peru. And it should be the same in Latin America, and it should be the same for the movement in general.
Oh, I just wanted to say that I really don't know, like, people have this really positive impression of Singapore, but I assure you that, and everyone, that civil society in Singapore really respects everyone else, and we have a lot to learn from everyone. Like, our Southeast Asian counterparts all pity us because you're so pathetic, and we're always learning from them. So yeah, I guess Singapore has a lot to learn from Peru and everywhere. Yeah, so, and I really like the point about not compromising as well, because that's a problem that we really have in Singapore.
Okay, it looks like. Yeah, I think.
Thank you very much.
Okay, so I guess we can all have a lot to learn from each other. Peru is really in the limelight now. That everybody is thankful to you and your colleagues for having pushed this forward to actually show the world that it is not only technically feasible to implement what is required, what the committee explained under general comment number 1, but it's also politically feasible, and I think those two things are really crucial and a huge contribution. So let us keep on working on the remaining pieces and learning from each other. Does anyone else have any final comments or questions? And we're actually coming to the end of this time. We're going to have the recording available. So thank you so much, Alberto, and I'm sure we will stay in touch. If anyone has questions for Alberto, please just you can send them to me, and I'll bring Alberto into the discussion. Okay. Thank you. And
Thank you. Gracias.
Thank you, everybody. Goodbye.
Goodbye.
Bye.